One of India's biggest political cases just took a shocking turn. A court in Delhi has refused to accept the ED's charge sheet against Congress leaders Rahul Gandhi and Sonia Gandhi in what's known as the National Herald money laundering case. Now, if you're wondering that what this case is all about, why two of India's most powerful political names are involved, and what just happened in court, you're not alone. This case has been going on over for a decade. It involves hundreds of crores of rupees, real estate properties worth thousands of crores, and serious allegations that the Gandhis and their associates used a company to illegally acquire massive assets at a fraction of their accurate value. The ED investigated, the ED filed charges, and now a Delhi court has said, no, we can't accept this case right now. But here's the thing, the investigation is not over, it's continuing on a different path. So what exactly happened? Why did the court refuse to accept the ED's case? And what does this mean for the Gandhis and for India's investigation agencies? Let's break it down. Well, hello, I'm Khatija, and today we are breaking down one of the most important legal developments in Indian politics. But before we move ahead, do subscribe and press the bell icon for all the latest updates. Now let's understand what this National Herald case is really all about. Starting from the beginning, the National Herald newspaper was founded in 1937 by freedom fighters, and the company that ran it is called Associated Journals Limited, or AJL. Over the decades, AJL built up valuable real estates in cities like Delhi, Mumbai and Lucknow, with the value of these properties estimated at around 2,000 crore rupees by 2010. AJL also had a loan of about 90.25 crore rupees from the Indian National Congress, which claimed it had advanced this money to keep the paper and its operations alive. In 2011, a new company called Young Indian Private Limited was set up with a paid-up capital of just 5 lakh rupees. Young Indian then took over the Congress loan of 90.25 crore rupees owed by AJL and in return received about 99% of AJL's shares, effectively giving it control over AJL and its properties. Sonia Gandhi and Rahul Gandhi together hold 76% of Young Indian, which is why their names are central to the case. Critics and the ED says this structure allowed a company controlled by the Gandhis to gain control of assets worth around 2,000 crore rupees for a relatively small effective outlay. While the Congress maintains this was a lawful internal restructuring to save a legacy institution. The legal battle began when BJP leader Subramanian Swamy filed a private criminal complaint in a Delhi court between 2011 and 13. Alleging cheating, criminal breach of trust and conspiracy in the way Young Indian took over AJL. He argued that more than 1,000 original AJL shareholders were sidelined, that a political party's funds were diverted for what became a commercial arrangement, and that the transaction violated several provisions of law. In 2014, a magistrate took cognizance of Swamy's complaint and summoned Sonia Gandhi, Rahul Gandhi and others. That original criminal case is still pending and the Gandhis are on bail in it even today. Later, the Enforcement Directorate entered the picture and opened a money laundering probe under the Prevention of Money Laundering Act, or PMLA, based on material from Swamy's complaint and income tax records. The ED's stand is that the takeover of AJL by Young Indian amounted to laundering of proceeds of crime linked to alleged cheating and breach of trust. And in 2025, it filed what PMLA calls a prosecution complaint, similar to a charge sheet before the Rouse Avenue court in Delhi. That complaint is reported to name Sonia Gandhi, Rahul Gandhi, Sam Pitroda, Suman Dubey, Sunil Bhandari, Young Indian and Dotex Merchandise as accused. The turning point came on 16th December 2025 when Special Judge Vishal Gogni refused to take cognizance of the ED's prosecution complaint and issued a detailed order running over 100 pages. The judge did not go into whether the Gandhis are guilty or innocent. Instead, he focused on how the ED had brought the case to court. Under PMLA, a money laundering case is supposed to build on an underlying or predicate offense such as cheating or criminal breach of trust, which is normally registered through a police FIR or a similar complaint. In this matter, the judge noted that the ED's complaint was not founded on any police FIR for the predicate offense, but flowed only from a private complaint and the magistrate's order in that case. and held that such a route to a PMLA prosecution was impermissible in law. The order underlined that an FIR is not just a formality but the starting point of a regular criminal investigation and cited Supreme Court decision that require a proper predicate case to anchor money laundering proceedings. Because there was no such FIR when ED launched its case, the judge declined to accept the prosecution complaint for cognizance and made it clear that it was a decision on jurisdiction and procedure, not an assessment of the underlying facts of the National Herald transaction. So in simple words, the court said the ED used the wrong legal door to enter the courtroom. Politically, Congress has projected this as a major moral and legal win. Leaders like Pawan Khera and Muhammad Khan said truth has prevailed and argued that the judgment exposes what they call the illegality and political vendetta of the Modi government against opposition leaders. Party spokesperson Supriya Srinathe said there were no proceeds of crime or actual transfer of property in the manner alleged by the ED, and that the case was part of a wider campaign to tarnish the Gandhis' image, which the court had now rejected at the threshold. Senior leaders such as K.C. Venugopal and Mallikarjun Kharge claimed that the order vindicates their long-standing charge that central agencies are being misused to harass political rivals.
मैं समझता हूं कि कहावत है, सत्य परेशान हो सकता है, पराजित नहीं। बहुत ही स्वागत योग्य कदम है और निश्चित रूप से सत्य की जीत है। ये मैं कहूँगा सत्यमेव जयते। मैं यही कहना चाहूंगा और काफी हमारे लिए एक खुशी की बात है।
ज्यादातर कांग्रेस के जो लोग हैं वो शुरू से कह रहे हैं कि ये एक तरीके से पॉलिटिकली मोटिवेटेड मामला है।
डिफरेंट मैं कह सकता हूं कि ये एक प्रायोजित, और ये भी प्रायोजित किसके, भारतीय जनता पार्टी के द्वारा प्रायोजित है और छवि धूमिल करने का प्रयास है। लेकिन ये मैं जरूर कहना चाहूंगा, जो सोनिया गांधी त्याग की प्रतिमूर्ति है, उन पे इस प्रकार का आरोप लगा रहे, जो मनी का ट्रांजैक्शन ही नहीं हुआ, मनी लॉन्ड्रिंग कैसे है, ये एक अहम प्रश्न है। इसलिए मैंने कहा कि सत्यमेव जयते।
On the other side, the BJP has stressed that this is not an acquittal and that the original Swamy complaint case continues. Spokespersons like Gaurav Bhatia have pointed out that Sonia and Rahul Gandhi remain on bail in the base cheating and conspiracy case and that the court has not given them a clean chit on the merits of the allegations. From this perspective, the order is seen as a setback for the ED's current complaint, but not as the end of the road for legal scrutiny of the National Herald deal. A crucial new development in the background is the fresh FIR registered by the Delhi Police's Economic Offence Wing on 3rd October 2025. This FIR based on a complaint from the ED named Sonia Gandhi, Rahul Gandhi, Sam Pitroda, Young Indian and others invokes cheating and conspiracy provisions under the Indian Penal Code. The trial court's December order specifically notes the existence of this FIR and says that, in view of it, the court is not going into the factual merits of the ED's present prosecution complaint, leaving room for the agency to proceed afresh on a more legally solid basis. Reports suggest the ED is likely to appeal against the refusal to take cognizance and may file a new prosecution complaint rooted in this October FIR, while the original private complaint case filed by Subramanian Swamy also continues separately. That means the broader legal and political fight around whether the AJL Young Indian transaction was a lawful restructuring or an abuse of power to corner valuable real estate is far from over, even though the ED's first attempt to prosecute under PMLA has hit a procedural wall. Now it's legal technicalities versus political allegations. What do you think? Who is right? Share your views in the comments below.